Your views as attorney for Mr. Singh on what transpired in court today.
We are witnessing another spate of politically inspired and politically dictated charges. The offense for which these accused persons have been charged this is the first time these offenses have ever been instituted against anyone. They did not even serve the summons on the defendants, but Singh and Brassington attended court voluntarily, and the magistrate granted bail. Now, having made the decision to grant bail, that means that the magistrate is satisfied that the accused persons are going to be present when their trials are fixed. Once that is established, then bail should be within the affordability of the accused persons. To fix bail in the sum of $2 million each per case jacket, it is exorbitant, excessive, and amounts to no bail. And it's unfortunate that the magistrate exercised her discretion in that manner. The accused persons now are trying to get assistance from persons to raise the bail. And then one can discount the fact that the prosecutor has indicated to the court that there are likely to be more charges. More charges will attract more bail. There will come a time where people will not be able to afford bail, and they will have to be remanded to prison because of impecuniosity. That is not justice, especially when one examines the charges. What has Ashni Singh done? What has Brassington done? They carried out instructions given to them by a board of a company and by a cabinet that employed them. They could not have disobeyed those orders. And what is the wrong? They did not profit. There is no allegation anywhere that there was any fraud, that there was any dishonesty, that they profiteered in any form or fashion from these offenses. So one has to understand what are these offenses about.
Between now and when the case is recalled again, are you likely to challenge these charges in the High Court?
Well, we are challenging the charges in the High Court. That challenge is ongoing. I was hoping that the magistrate would have permitted me some time to address her on that issue, but she proceeded to deal with the issue of bail, and I intend on the next occasion to address her at length that she ought not to proceed until the challenge filed in the High Court against the legality of these charges are completed.
But I think what we're witnessing here in this country now is the erosion of the justice system in Guyana. The very fact that you have such an exorbitant bail on such a charge that the defense is considered to be frivolous, that is why they're making an application to the High Court, because they believe that the charges are frivolous. And to put a bail of this nature tells us that there is some deliberate attempt by the executive to undermine the whole justice system in our society. That is what is taking place in Guyana.
But attorney, is $2 million a lot for two persons that don't reside in the jurisdiction? Isn't the bail?
These persons are working out of the country. Once their case is called, they will be here. They have given no indication that they are not prepared to submit themselves to the jurisdiction of the court. As I indicated to the magistrate, the fact that they came voluntarily and not because a summons was served on them is an indication that they have submitted themselves voluntarily to the jurisdiction of the court. So that is not a factor that one should take into account. If you wanted them to prevent them from traveling, then you should have perhaps remanded them or take their passports. But to impose a punitive sum as bail is tantamount to refusing bail. Significantly, when one reads the charge, if they are to prove everything that they say on that charge sheet, it does not amount to an offense in law. It does not amount to misconduct in public office. Selling a property without a valuation, but at a price determined by market forces, how can that be an offense?
Well, let me just make this all.
How can that be an offense?
And before you do that, sir, with as it pertains to bail, are friends going to be the persons lodging the surety for these
persons
two gentlemen?
are assisting in raising the sum to lodger's bail.
Because they can't afford
Because
it.
they cannot afford it.
But it's not cash bail.
With surety?
It's certified checks at the bank. For us to get surety to be used other than cash, we have to go not only get a transport of a property, but get a recent valuation. We can't do that now because we don't have time available. It means that they will have to be remanded. They will have to spend the night in police custody.
But
and we are trying to avoid that.
The point I would like to
So
make
it's a
of what
manager's check.
What is taking place here is the fact that we have had this experience before. And we're going down the same road. And where it is heading for, it's the economic and social ruination of our country and the total undermining of our democratic and constitutional institutions. That is what we see, the beginning of what we're seeing taking place right now, or what we just witnessed here.
Thank you.
Mr. Nandla, is your client working overseas?
My client is gainfully employed, yes, he's working.
And how would this case impact?
I have not discussed that yet, but it cannot impact positively on his employment. It cannot. I can tell you that without even speaking to you.
Are you ready?
I'm ready.
Go ahead.
I think what we just witnessed is an indication of things to come in this country. We are going right back. If we have gone in 3 years, democracy has been undermined severely, and we're going right back to a kind of a police state. This is sheer political vindictiveness, and it's a vicious attack on the character of two people who have contributed so much to the development of Guyana. And this tells us what is ahead for this country. One, it's going to lead our country into economic ruins, and it is a total undermining of our democracy, of our institutions. That the very fact that these people have been charged, when the charges, to my mind, have been very frivolous, and they dropped the charges which were more serious against ministers of the government, present-day ministers of the government, tells that discrimination, political and racial discrimination is alive and well in Guyana.
But what about the argument that these two men should be accountable for their actions?
But they have been accountable, and all the charges have been trumped-up charges, fictitious charges, without. And one of the things that I have been very surprised about is that the defense got an application in the High Court to quash these charges because of it seems to be so frivolous. So frivolous that we have an application in the court, and here it was refused, and then look at the bail that these people have been put on, which tells us that there's much more in the mortar than the pestle.
So you're thinking that the bail is exorbitant?
It's exorbitant, extremely exorbitant.
But these are two men that don't live within the jurisdiction, and could be a potential flight risk.
As I think the defense argued just now, that is inconsequential. What is important is they have come on their own volition. They are not of that. They have a character, they have reputation, they have a track record, and both have been citizens, outstanding citizens of our country. And to do this, to me, is a travesty.
Mr. Brassington, would you like to say anything? Let's just say, would you like to say anything? Let's just say, would you like to say anything?
Sorry. Hi,